Good evening. My name is Lukas Amato. I am a postdoctoral researcher here at the University of São Paulo Law School. And this is the fourth day and last day for this week of our seminar cycle on Luhmann and Socio-Legal Empirical Studies. We'd like to thank everyone that came during this week for these sessions, and mainly the professors that presented their work during this week. And I would like to thank all the panelists in the person of the inspiring researcher, Professor Álvaro Pires, that now is watching us and that gave 2 lectures this week. We'd like also to thank, in a very special way, Professor Celso Campilongo, who is the Vice Dean of our law school, and who gave all the support and the enthusiasm for us to organize this cycle of seminars. And he is our leader in this and in other academic endeavors. I need also to thank my colleagues Marco Barros, who gave the first idea of the topic for this seminar series, Gabriel Fonseca, who came from Salvador to help us organizing this week, and who is organizing the coming of Professor Alphonse Bora next month. So in September we will have 4 sessions of the seminars with Professor Bora from Bielefeld and Professor Bettina Lang from Oxford. And also I would like to thank Fernando Bezzi, who is also helping us with the operations. And to complete the list of acknowledgements, we need to mention the crucial support from FAPESP, which is São Paulo State Research Foundation, and the funding also from CAPES, the National Agency for Higher Education, both institutions that help you to have some intelligent life in this country despite the circumstances. And so we invite everyone to keep with us and follow us at the blog of this seminar, which is empiricalsystemstheory.blogspot.com. And today we will have a special evening dedicated to the sociology of constitutions and courts. And this is an important topic for our Department of Philosophy and Theory of Law. This morning, Professor José Eduardo Faria, Professor Celso Campilongo, and we began a second edition of a course on the sociology of Brazilian constitutionalism. So this topic is of interest of many professors and students here at our law school. We will have, in sequence, the 3 conferences of today, starting with Professor Thornhill, who is the main reference in the sociology of constitutions with a systemic approach. He is now the Dean of the University of Manchester Law School. So thank you very much for being with us. We know you have an extensive journey here in Brazil. So thank you for adding us to your schedule here. And secondly, we will have Professor Lukas Sosoe from the University of Luxembourg. He is a refined political and legal philosopher. He works with Kant, the German Romantics, and also with Luhmann, and has a very important work in the translation of Luhmann's books to the French. He's now working on the translation of the fundamental rights as an institution to the French language. So I would also like to thank you, Professor Lukas, for being with us this entire week. And finally, we have Professor Carina Calabria, who is a Doctor of Laws by the University of Manchester, and a scholar on the topic of international courts. In the name of all the organizing commission, we would like to thank you very much for being here, for presenting your research, and also for helping us bringing Professor Thornhill to this session. So, not to take more time of you, I'll give the words to Professor Thornhill to present his lecture.
Thank you very much indeed. Thank you everybody for attending the session, and thank you very much indeed to Lukas and other organisers for inviting me to this magnificent university. It's always, I think I gave a lecture in the same room exactly a week ago with a totally different research group. And I realised immediately that this is one of the world's great universities, and its influence within the political structure of Brazil is immediately tangible, it's immediately palpable when you come near the building. So it's a great pleasure to be here. I feel very honoured. And so please receive my gratitude for that.
Thank you, Professor. Thank you for, first of all, thank you for the invitation. Thank you, Lukas. Thank you, Professor Celso, Campilongo. Thank you, Marco, for the organization of this event. Thank you for giving me the opportunity now to complement. As you're going to notice, as Professor Chris Thornhill posed, our presentations, they are related. We're going to write a chapter on that, but there are specific points that we disagree. It's not going to be in the article, but they may be visible here, and that's okay.
We put footnotes in there.
Yeah, we can put footnotes. So while Professor Chris Thornhill was talking about this process of differentiation of the military system and the political system, I'm going to be focusing on the legal system itself, so in the differentiation of the legal system. And my main objective with this is not so much to discuss citizenship, but to discuss legal differentiation and full inclusion. Full inclusion here, if you look at system theory, you can be included in certain partial systems, but not necessarily included in all of them. And when I talk here about full inclusion, I'm thinking about an individual who is included, if not in all partial systems, at least in the essential ones. When I think about essential ones, I think about the ones that are related to rights, to fundamental rights. So the right to education, the civil rights that are related in the political system and in the legal system itself. So this is my main objective. I'm going to discuss here full inclusion. My object is going to be international courts, as Lukas presented. My expertise is in international courts. For that, I come from the field of the sociology of international courts. This means that I do not take not only a legal approach, but a sociological approach. And my object is not only courts, but international courts. And I'm basically looking at the efficacy of these international courts. So this poses some questions. The first one is, why courts? So in his systems theory, Luhmann puts the courts at the center. He doesn't talk about a hierarchy of the court, but he puts courts in the center of law. And why does he put courts in the center of the legal system? Because they say that courts are always facing the very paradox of law. He says that courts have to face the central paradox of the legal system. There is no inherent value or logical operation that decides what's legal or illegal. And this is very important. He says that only courts have to transform indeterminacy into determinacy where necessary. Only courts have to construct fictiously the availability or unavailability of principles where necessary. And why is that important? Because when you think about what's legal and what's illegal, when you think about the code of law itself, legal doesn't mean fair. Legal does not mean necessarily good. Legal is contingent. Legal does not mean that you're taking a more fair decision or that you are necessarily relating to justice. And the case study that I'm going to bring here, which is amnesty, I actually had 3 case studies. But for today, I'm going to present in detail the one of amnesty. And when you think that until the 90s, amnesty was legal, And now you have a strong jurisprudence of the Inter-American Court, but also of organs of the United Nations precluding amnesty. You can see that the code legal, illegal sometimes is not sufficient to bring full inclusion. What happens is that until the 1990s, this code of legal and illegal and the legality of amnesty would exclude all victims of military regimes, all victims of coup d'etat, with the idea of amnesty. They were completely forgotten by states. They were invisible. Because in that moment it was more important to refound the state. So peace was a value that had a greater visibility than justice itself. So this is going to be my object. I'm going to study international courts. I'm going to talk about the efficacy of international courts. And my main question here is to understand that although courts are located in the center of the legal system, sometimes courts have been performing an ambiguous role in the process of legal differentiation and inclusion. And here it's important to see the different role that domestic courts and international courts have both in the affirmation of legal differentiation and inclusion. Before talking about courts itself and about international courts, I think it's important to take a step back and to talk a little bit about this field. First, because it's a recent field. Second, because we are talking about Luhmann, but in these days we have been debating how systems theory lacks of a stronger reflection on the global system, on international law, and therefore on international courts itself. So, in the study of international courts, which is a recent field, you can divide the first studies in at least 5 or 6 groups. So the first ones are historic studies. So they want to understand what were the historical conditions that gave rise to a multitude of international courts. After that, after these first historic studies, you have taxonomic efforts. These are studies that try to map, classify, and understand the legal structures that form this international legal system. After that, you have a very prolific field of study that's formed by endogenous studies. So after understand the historical context, after trying to understand and classify these courts, finally academics, they try to understand the nature, the structure, the function, the composition, the procedures of international court. In these endogenous studies, it's very important to see studies that try to understand the function, the purpose of courts. And why that? Because when you finally start to study the efficacy of international courts, function is very important. They say that if you understand the function, if you understand the purpose, then you can limit the action of the courts, and then you can understand how far they can go in that function, in that goal. Still in these studies now, that they do not talk just about international court, but they talk about the efficacy, they deal with the efficacy of international courts. You have studies, another prolific area, that try to understand the conditions, factors, and variables that determine the efficacy of courts. So instead of just observing the process and the efficacy itself, they try to determine all the variables and all the factors that may help a court to have more efficacy or not. This is like an endless list. If you try to see all single factor, it's an endless list, and at the same time, it's impossible to detect all these factors that may or not affect the efficacy of the court. You also have compliance studies, and this field of studies are very problematic because most of the times they have a very legalist vision. So what they say is, if you have a court with high rates of compliance, you have efficacy. If you do not have this, you do not have efficacy. And then when you look at the Inter-American Court of Human Rights, for example, which has a jurisprudence of around 200 cases, and in which 80% of these cases were not fully complied, and if you reduce the efficacy of this court only on compliance, you're going to say, okay, there is no efficacy in the Inter-American Court of Human Rights. But if you do not understand processes, if you do not understand the effects that this court had at the domestic level, if you look just at the compliance of the cases, then you're going to have a half explanation of the real impact of this court. And finally, you have studies that deal with the legitimacy of this court, which means in these legitimacy studies, they are divided in two groups. Some of them, they are normative, so they say, are these decisions compliant? Are these norms compliant? And the second one deal with effectiveness. When I was trying to evaluate the efficacy of international courts, both exploring these historical, these endogenous studies, and the efficacy field, I could not find a theory, I could not find a methodology that was allowing me to understand efficacy in a sociological manner. So I could understand efficacy in a legal way, but something was missing. In order to deal with that, I tried to construct an efficacy chain, which is a chain formed by different layers. Each of these layers allow you to observe different phenomena, and with this I could finally visualize social processes. So I construct a chain formed by 5 layers, in which, for example, in the layer of application, I could see if domestic courts were applying the decisions of an international court. In a layer of strengthening, I could see if a decision of an international court was repercuting domestically and was creating stronger institutions, stronger norms, stronger social movements. Through a third layer of implementation, I could see if decisions of international courts were implemented or not. And finally, through a layer of adequacy, I could see if the legal order was being adequate or not to a decision of an international court. Why is that important? Because, for example, when Luhmann talks about the paradox of human rights, which means that the human rights, they become more prominent and they become more visible and they become stronger when they are violated. What I think is that Luhmann is having a unidimensional vision of law and of efficacy and of human rights. If you observe, for example, this efficacy chain and these different layers of law, you're going to see the violation only corresponds to one aspect of strengthening of your human rights. So if you have a coded human right, this means already that you had an advance, although this may be violated. And for example, if we think about the presentation of Guilherme, in which he was talking about the visibility or invisibility of racial rights in Brazil and the advance of these rights, what you can see is that these rights, they are not become stronger because they are violated. They have been violated for a long time. What actually made these human rights stronger was the embedment with international law that made these rights finally visible. You could see these rights and then you could identify the violation and you had a process of codification. So what's important here is to see these different layers that make you see the efficacy of decisions and of courts, and try to not think only in the terms of this paradox of human rights in which you're just looking at violation and not to social process that can make rights more visible and with more efficacy. So here, coming back to my central question, now that I presented the field from where I'm studying, which is this field of efficacy of international courts, and now that I presented also my object, which is international courts, I would like to start responding some questions. And my main question here is that although located in the center of the legal system, courts, and specifically domestic courts, they have been performing an ambiguous role in the process of legal differentiation and inclusion. So why? Why is this process happening? So first, and I think Chris's presentation was already mentioning this point, you do not have a complete legal differentiation. I know that in Chris' presentation he was talking more about military and political differentiation, and I tend to analyze more legal differentiation. And in my opinion, you do not have a complete legal differentiation. And this makes sometimes with courts that are the center of the legal system, they are operating under the code of other legal systems. They are not operating under the code of legal and non-legal, especially if you're not looking at international court but at domestic courts. A second reason, the code legal-non-legal is not adequate to guarantee differentiation and inclusion. And here I'm going to bring a case study on amnesty. But sometimes what's legal and non-legal is not going to guarantee inclusion. And then again, if you think about slavery, while slave was legal, the system of law, you could see that at least regarding to the question of slavery, was differentiated. You did have autopoiesis, but you did not have inclusion of an important parcel of the population because it was legal to be a slave. So what are the processes that are actually taking inclusion seriously, that are apart from this simple code of legal and non-legal? And here I repeat again, legal and non-legal does not correspond to good or not good, does not correspond to an idea of justice, does not correspond to an idea of what's fair. Even actually the idea of justice in Luhmann, this reference of justice, it's a reference of justice as an equal treatment. And an equal treatment to which subjects are included in this equal treatment. So again, the code of legal non-legal is not adequate, not sufficient to bring inclusion. And inclusion, as I'm understanding here, as full inclusion. And third, and this is the most, one of the most important points that respond to this question, why domestic courts, they have been performing an ambiguous role, is the lack of embedment of domestic courts, domestic decisions, and the domestic legal order in international law, in human rights. And here what I'm proposing is that human rights, they should function as a meta-norm that actually cuts across different systems, promoting or not inclusion. So more than the code legal, non-legal, Chris talks about the code right, non-right. Maybe what I'm trying to advance is a code of inclusion, non-inclusion. Because even if you have the code legal, non-legal, or even if you have the code rights or non-rights, you're not talking about all subjects that could be included in this system. And now I'm going to respond to each of these hypotheses. So the first one, that you do not have a complete legal differentiation. I'm going to leave this for Chris's presentation because it was presented exactly the formation of the nation state, how you had this process of differentiation between the political, the military, and the legal system. I'm going to go to the second assumption, which is that the code of legal and non-legal is not adequate. And then, again, if you think that for Luhmann the only function of the legal system is to create apaziguate normative expectations, you see that the sense of the legal system is not necessarily to promote inclusion. You have to have, you specify these expectations, which means including that you can have disappointments, you can have violations, as much as you have law pacifying this, what should be done. But not necessarily you're talking here about inclusion, not necessarily you're thinking about rights and about rights for all individuals. And then I'm going here for the last assumption, which is the lack of embedment in international law and human rights law. So here is important to think about how this paradox that Luhmann poses, this claim of validity based on violation of law, it's unidimensional. You have to understand the process of affirmation of human rights as a process. In this process, sometimes you're going to have more violations, not necessarily because they are occurring more often, but first because they are becoming more visible. At first, they were not understood as a violation. Then they become more visible and you understand the violation. And for me, the moment in which you have these rights really strong are not when the violations are happening, are in an after moment in which these rights are pacified and the number of violations, they start decreasing. So to understand better some of these concepts and some of these assumptions, I would like to bring here the case of the amnesty laws. Actually, I had here 3 case studies to prove some of these points, to contextualize some of these points. The first case study is the intellectual property regime in correlation with the defense of traditional knowledge of indigenous and tribal people. The second one was a case study about judicial independence. And my main idea, studying judicial independence, and in this sense, these dialogues with Chris' assumptions, is that we have been so occupied and so worried about providing judicial independence that nowadays you have almost as a hyper-inclusion of judicial actors. So we thought so much about having judicial independence that now they are hyper-included in a system. And maybe this theory is right. You do not have a political system that's so strong anymore. But at the same time, the code of the system of law of these judicial actors is not only law anymore. It's not only legal and non-legal. And then finally, I have the case study of amnesties. And I'm going to talk now about 5 points about amnesty, about the development of amnesty and how they are related to other points that I mentioned before. So the first one is the process of development of the code legal, non-legal regarding to amnesty. If you look at the time frame of amnesty, you can see that up until the end of the Second World War, amnesties were considered a reasonable mechanism to end international conflicts. Regarding to that, after the Second World War, and between 1945 and 2010, over 500 amnesty laws were registered in more than 100 countries. So amnesty was a common practice. Not only was a common practice, as it was a legal practice. So both domestic and international law consider amnesty as a legitimate political tool to end conflicts and facilitate transition to democracy. The victims did not have a voice when you were talking about amnesty. By trying to privilege the formation and making peace in the state itself, victims were not considered they were not included both in the political and in the legal system. They were just invisible. So in Latin America, amnesty is also constituted a very common phenomenon. You have only Belize, Costa Rica, French Guiana, and Paraguay, which means that you have only 5 countries in Latin America that never had an amnesty. So what you see is that they were common here in Latin America, and they were legal. And then you finally start to have a different movement. And what's interesting in this movement? You have a centrality of courts, but not domestic courts, but international courts. So this change here, it doesn't start because you have a violation, because you have an amnesty. You have a change because international law starts to understand that amnesties, they are not legal. So first of all, you have in 90s, you have the UN, the United Nations. They are in an era of accountability. So they say that the perpetrators of human rights violation, they have to be accountable. So this is a first change. Even with this change that starts in the United Nations, you can see that this organization has a very mild position. They still think that amnesty and law, peace and justice, they are conciliable. So what the United Nations says is that justice and peace are not contradictory. Rather, properly pursued, they promote and sustain one another. Experience has shown, although, that a culture of impunity and a legacy of past crimes that go unaddressed are likely to undermine a lasting peace. And here what you see is an attempt of balance. Politics and law, an attempt to balance these two systems as balance. But what you actually see that happens is that the legal system takes a preeminence especially by the work of international courts and the Inter-American Court of Human Rights, and then you were not guaranteeing only peace anymore. What the Inter-American Court starts to say is that peace, and even in this sentence, the United Nations, that a peace that do not guarantee the right of victims is not sustainable. So now I'm going to pass to the centrality of the Inter-American Court on the construction of the jurisprudence on amnesty. And through this jurisprudence, the Inter-American Court, in my opinion, pushes legal differentiation and full inclusion. Because now you're not going to have only the formation of the states and the formation of citizens, but you have to guarantee rights, especially the rights of victims that suffered any kind of abuses during periods of pre-amnesty laws. So some general aspects of the jurisprudence of the Inter-American Court. The jurisprudence of the Inter-American Court mentions the word amnesty in at least 49 decisions. This means 25% of the jurisprudence of the court. So you can see that this is a central aspect of the jurisprudence of the court. Second, after 2001, you see that the court started not only to mention, but only to decide cases that have amnesty laws as the centrality of these cases. So far you have 7 decisions involving 5 countries that are related to amnesty. So you have Barros Alto y La Cantuta, related to Peru. You have Almonacid Arellano, related to Chile. You have Gomes Lundi, and more recently you have the case of Herzog versus Brazil. And finally you have the cases of Hellman versus Uruguay and Massacres em Mozote against El Salvador. What's interesting? The jurisprudence of the Inter-American Court, although it's related to only 5 states, has led other countries like Argentina to preclude their amnesty laws. It also led countries as Colombia to pursue a process of peace in which this amnesty jurisprudence was taken very seriously. And what are the elements of this jurisprudence, of these 7 decisions and these other 49 decisions that consider amnesty? So first of all, impunity. The court starts a war against impunity. So what it says is first, any amnesty that guarantees impunity should be voided. This included self-amnesties and black amnesties. Furthermore, any other kind of restrictions, not only amnesty laws, but any other kind of restriction that is going to let in impunity should be voided. And in this matter, the court has, for example, decided in some cases in which states use, for example, the decision of a case and the res judicata as a reason to keep impunity. The court has challenged this principle, and this is a basic principle for lawyers. If you res judicata, you have a decision, you cannot start again. The Inter-American Court has disputed this principle of res judicata because it says that you cannot keep impunity. And in some cases, especially some Chilean cases, the courts actually took the decision of the Inter-American Court and they broke the principle of res judicata to decide cases against, considering the perspective of human rights and considering that they could not leave crimes impune. There are other pillars, other elements of the jurisprudence of the Inter-American Court in amnesty as well. The first one, and this is really important, is that the court says that victims of amnesty laws are deprived of certain rights, like the rights to judicial protection, the right to integral reparation, the right to truth, and the right to memory. Second, the court also says that some rights, especially non-derogable rights, the seriousness of these crimes cannot let these crimes be prescribed. So there are some rights. The court doesn't use the word "use cogens," but it does employ a classification that's very similar to use cogens. And the court says because these are non-derogable rights, you cannot use any kind of excuse like, but we are reconstruct the state. We are trying to pacify a situation of conflict. We are avoiding other violations. The court doesn't accept. And here what's important is to see that there is no flexibilization of the code legal, non-legal. For the court, it's non-legal. Amnesties are non-legal. There is no possibility, including if it's a self-amnesty and a blank amnesty, including if the reason is to restate the peace in the state, you have no flexibilization of the code legal, non-legal. Actually, what you have is an expansion of what is not legal based on rights and based on inclusion, and here inclusion of the victims. Another important element of the jurisprudence of the court is the inadmissibility of mitigating circumstances. So this is a operational closure of the court in relation of this jurisprudence on amnesty. Another element is the principle of non-obviation of justice, which means that here the court says this is a matter of the law. Here in certain way, I'm reaffirming what Chris was talking about, this hyper differentiation of the law system. The court does not admit to use political elements or political excuses or even political mechanisms to try to not make justice to the victims. So by using the principle of non-obviation of justice, the court says truth commissions, for example, are a very good initiative, but still you need to bring these victims in front of a justice. You need to resolve this in the legal system. You cannot resolve this in a different system. And what is the impact of this jurisprudence of the Inter-American Court on domestic legal systems? I think that the way to summarize this is that you have contingents if it's not related to international law. So domestic jurisprudence has been faltering. Sometimes you have a great defense of domestic courts, but this can change in just 5 years. And I think the main case here is Uruguay. But let's go case by case. So first you have Peru. As Peru had the first case decided by the Inter-American Court in 2001, which was the case Barros Alto, and after that La Cantuta, you would say that Peru is the country with the strongest response to the jurisprudence of the court. So you have that both the president of the Supreme Court and the Attorney General, they demanded that amnesty laws should no longer be applied by courts. Also, you have the famous process that extradites and prosecuted former President Alberto Fujimori for perpetrating crimes against humanity. So Peru responds in a very positive way to the decisions of the Inter-American Court of Human Rights. And you can see that this embedment between domestic law and international law allowed social movements in Peru, strong social movements in Peru, to bring cases to courts, including a case against the president, and include victims in this process. You have a case here of inclusion of victims in this dialogue of amnesty. You also have the case of El Salvador, in which until 2016, domestic courts were very close to the jurisprudence of the Inter-American Court, but finally in 2016, the Constitutional Court declared unconstitutional the General Amnesty for Peace Consolidation Law of 1993. So both in Peru and El Salvador, you have domestic courts using these the social movements, using these decisions of the Inter-American Court to guarantee inclusion of victims and differentiation of law from the political system. You could not use the argument anymore of consolidation of the political system, stabilization of the political system to deprive victims of their rights. After Peru and El Salvador, you have Chile. In Chile, the Supreme Court has a faltering jurisprudence, so sometimes the jurisprudence goes toward the Inter-American Court, sometimes it deviates. But what's important is that since the Inter-American Court's ruling, Chile's amnesty decrees has not been applied. So you have, if you think about a chain of efficacy, if you think not about violation, but if you think about different layers that make a law, that make human rights laws, stronger or not, you can see that Chile, in some of these layers, have been restoring the rights of the victims. In Brazil, Brazil is undoubtedly the least compliant state in the region. Actually, what you have here is a decision of the Supreme Court that upheld Brazilian amnesty law. But at the same time, the decision of the court in Brazil allowed social movements and allowed a certain level of litigation in first instance courts against the amnesty law. And finally, we go here for the most interesting case, which is Uruguay. And that makes us think about the differentiation of law and politics. And more important, makes us think about democracy. Chris started his presentation talking about differentiation of politics and differentiation of military. And earlier today, we were talking about how we should abandon some of the semantics that we use to describe democracy. In this case of Uruguay, it's really interesting to think about that. So what happened is that Uruguay in 1986 had an amnesty law. This amnesty law was approved through a referendum, which means that the population of Uruguay said, okay, we want an amnesty law is approved. If you use a classic semantic of democracy, you're going to say, you have an amnesty law, but which is different of the other amnesties in South America. It's not a self-amnesty, it's not an amnesty declared only by the military, but it was actually approved by the population of Uruguay. But then in 2009, after decision of the Inter-American Court, the Supreme Court neutralized the amnesty law. So you had the Inter-American Court with a very strong jurisprudence say there are no way, even through a referendum, that you can't maintain an amnesty law. You cannot use here arguments coming from political system to try to declare the validity of something that is violating the legal system and violating the right of the victims. So in 2009, the Supreme Court of Uruguay neutralized this amnesty law. After that, in 2010, you had here the Uruguayan Supreme Court reaffirming its decision. Because after this decision of 2009, you had a second referendum in Uruguay, which decided that was a democratic amnesty. So again, the population of Uruguay was saying through democratic means that the amnesty law should be upheld, that you should not declare void, you should not nullify that amnesty law. So in 2010, again, the Uruguayan Supreme Court reaffirms its decision, displaces the law, creates binding facts in all the cases. So here you have law again, you have legal, non-legal, and you have the decision of this court. After that, in 2011, to address these obstacles, Uruguay adopted a new piece of legislation repealing all amnesty law. So you could say that you had perfect embedment of the jurisprudence of the Inter-American Court and the Uruguayan legal system. But then, in 2013, you had a change in the Supreme Court, and then you had the decision of the Supreme Court that shifts and compromises the control of conventionality executed by other domestic organs in Uruguay. Which means that the Supreme Court in Uruguay decided that the amnesty was legal again. And here, what is important here to think about what we've been discussing before? First, that you have no complete legal differentiation if you do not have embedment of international law. What happens here is that without international law and without the jurisprudence of the Inter-American Court, you would have legal amnesties in the whole continent. So in name of politics, in name of the stabilization of the political system, you would not have the law of the victims. You would not have legal differentiation, and you would not have full inclusion. The victims would be aparted from the social process, from the inclusion in the political system. Second, that the code legal non-legal is contingent. It's not adequate to guarantee differentiation and inclusion. So you can see that until the 90s, amnesties were declared legal, therefore excluding victims of egregious human rights violation. And even in Uruguay, the code after 2013, so only after 4 years, is reimposed a new code of what was legal and non-legal. Materially, what's legal and non-legal is contingent. And third, that the only way to provide a more stable, differentiated, and inclusive system is through the embedment of domestic legal systems in international law and human rights law, because then you can guarantee some stability. And you can see this regarding to that, the case of Uruguay is paradigmatic, because you had in just 4 years a complete change on what was established as something that was democratic, something that was legal, and that was not legal. So in that sense, I would say that in order to guarantee a more differentiated, stable, and inclusive, we can not only look at courts in the center of the legal system, but we also have to say what kind of courts. If we do not consider hierarchy, but we consider this idea of periphery and center, outposing this very center of the legal system, not only international courts, but each court, any court that is deeply embedded in international law, in human rights law. And this can be a domestic court, this can be a domestic legal warden, or this can be a court like the Inter-American Court of Human Rights. So thank you.
Thank you, Carina. Now let's listen to Professor Lukas Sosoe.
Yes, thank you very much, Lukas. Thank you for the invitation in. I thank you yesterday, but I repeat it today. I'm glad to speak to be the last speaker tonight, because our three papers have something in common. I'm going to talk about the position of courts, the centrality of the courts and the legal system. But you have finished your paper with the same topic, so this will be the core of my presentation. Since this chapter seems to be very important, I tried to choose some passages, but the whole day I had a problem with my machine, so there are a few mistakes in the quotation side I choose, but it is just to help understand what Luhmann wants to express by this chapter. And it is the chapter 7 of Law and Social Theory, Social System, and the story itself is very simple. It has to do with the internal differentiation of the legal system. And everybody knows that the legal system has evolved in the course of history. Presenting this history itself has some interest, but this is not the interest in the history of law, which is important here. It is a conclusion Luhmann's system theory draws from the history of the differentiation of the legal system, which is important for me here. Because what he tries to do is to make a short history of this differentiation, but the conclusion he draws from this history is a little bit negative for me, because he comes to the conclusion that law or legal decision is based on paradox, and that the courts are there only to unfold this kind of paradox. My question, and this is my last question, but I will ask it at the beginning, is it not possible to see things in another light, not to find another interpretation of this, of the centrality of the courts in the legal system? So he begins with a short, I will begin with the conclusion he draws from his analysis, which is the first quotation. Luhmann says, in the courts, if the courts are in charge of the task of unfolding the paradox of the legal system, as required by, at the same time, by the system at the same time, veiled by the prohibition of the denial of justice, it explodes the possibility of describing the differentiation of the legal system as a hierarchy in the form of a chain of commands. For the courts do not give orders to the legislator. At best, courts formulate conditions for what courts can understand, accept and practice, which with that formulation they do not insist on anything else but their own existence. Therefore, it is necessary to replace the model of hierarchy with the concept of the differentiation between center and periphery. This is the conclusion to which he comes. But how does Luhmann arrive at this conclusion? He begins by saying that general observations influenced by system theory and empirical research suggest that the differentiation of the system requires an internal differentiation, which is developing at the same time as the system itself develops. Internal differentiation means that, seen from the perspective of the subsystem, everything belongs to the environment, which does not belong to the system. The overall order of the system requires, furthermore, that the relations between subsystems be regulated either on the basis of equality or in various forms of inequality, or in various forms of inequality. So, for instance, where where there are a majority of courts, they are similar, they have to respect each other. However, forms of differentiation that have developed over a long period of time are based on inequality. For instance, courts and lawyers, courts and legislative parliament, which have introduced more differences and with them more degrees of freedom into the system on the basis of inequality. It is on this basis, or on these premises, that Luhmann explored the forms of the differentiation of the legal system, particularly the position of the courts as differentiated subsystem of the legal system. The question he wants to answer is the following: which form of differentiation is propelled upon legal system when it differentiates courts? More precisely, what was the relation between legislation and jurisdiction? For Luhmann, at the beginning, legislation and jurisdiction were organized according to the hierarchical architecture of the old cosmological order. So there are, at the beginning, something like an equality, a relation of subordination between jurisdiction and legislation. And this was an old form of, or an old idea, or an old understanding of the relation between the legal system, between jurisdiction and legislation. And if you take the, I already talked about, present the first quotation. But for Luhmann, the legal system was considered as the exact parallel to the political order. But with the time, the interpretation of laws and the self-determination of decision-making that had to be granted to courts could be withdrawn from them, could not be withdrawn from them. Constitutionality itself became an object of judicial interpretation. Courts had to decide how far they could demand change of laws by legislation if no satisfactory solution could be found. So the second quotation explains this idea. Luhmann says, and only this conception of the judicial task makes it possible to create norms about the prohibition of denial of justice, and to demand that courts must decide all cases brought to them by themselves. So the courts must now decide that on the basis of this denial, they are obliged to decide every case. So since the 19th century, and this is the idea of Luhmann, that even though they are granted the possibility to decide every case, the hierarchy, the idea of the hierarchy between legislation and jurisdiction remain. And for him, since the 19th century, the hierarchical model was weakened by changes, but without being challenged, let alone being replaced by another model of differentiation. The powers of interpretation of the judge in relation to legislation increase. Judges have faced a double pressure to decide every individual case and to decide it justly, and this means to treat individual case at least equally and apply the same rules. The obligation to decide and the freedom to find reasons to justify every decision which comes with that requirement is produced by it becomes limited by point of view on justice. So they were free to decide about every case, but the idea, the representation of what they were doing, the courts are doing, remain the same. So the people believe that they are subjected to the legislation. So despite these new important competences gained by the courts, the asymmetrical relation between legislation and jurisdiction remain, even if judges have the power to produce legislation type and, as a matter of fact, more judge-made laws. The idea of the hierarchical superiority of legislation over the judge was still dominant because the judges are bound by the laws. How can this be explained? The explanation Luhmann gives is that in contrast to legislation, the matter at issue is the application of laws. And the application of laws has been seen as something low, as a job which is less important than the legislation, what legislation does. So application of law by deciding in individual cases is not as to be placed as high as the legislation. The idea remains that decision is nothing else but a concrete job, and that developing rules is a parallel operation, but higher. But by the arrangement of an asymmetrical relationship between legislation and jurisdiction, and with the help of a terminology that supports it, for example, the doctrine of the sources of law, one tries to prevent a circularity, which will be the consequence of admitting that the court itself creates the law it applies. So admitting this idea will be secular and will not be just because we have a legislation. So what will be the role of the legislation if the court creates itself the law it supplies? This is the argument Luhmann was developing. So that in the third quotation you will find how he expressed this idea, presenting the decision of courts as a finding of law, as source serve above all the purpose of rendering asymmetric a relationship which otherwise would have to be presented as a cycle. However, the cycle will not come about at all. Courts could resort to a non-liquid in cases in which they could not find any law, and then would not have to decide. Unfortunately, says Luhmann, courts are not permitted by law to do that. Courts are put under the pressure to decide whether they can decide or not. And this has become a matter of course during the transition to modern times, that each action which is brought must receive a response, even if this is not explicitly prescribed. The important position of the court has its origin in the prohibition of the denial of justice, which appeared during modern times, precisely with the emergence of subjective rights. And this, for Luhmann, is not a coincidence, because during this time we have a predominance of the idea that the practice is higher than theory. So this is for him the interpretation. So it's the time of pragmatism. So deciding is concrete. And he says it's not a mere coincidence that the obligation of court to have to decide was formulated at exactly the time in which the philosophers announced the superiority of practice over knowledge. It is in mere coincidence. It is not a mere coincidence that it appeared in modern time, and with the appearance of modern social structure of the world and the awareness of the word complexity. And with this awareness of the complexity, people think that what is important is to take decisions and to take them quickly, because otherwise the world would not be not in order. And Luhmann tried to formulate it in this manner. That is why people believe that it's important to link the task of judicial lawmaking with the prohibition of the denial of justice. One can even go so far as to take the modern discourse of legal principle as a byproduct of the prohibition of the denial of justice. So for him, without the denial of justice, there will be no discourse on legal principles. Luhmann believes that the hard cases, for instance, in law, explain better the role of the prohibition of the denial of justice and of the central position played by the courts. Why the hard cases? Why are the hard cases so important? Because with the hard cases, the judge has to decide. There is no law, but he has to perhaps refer to moral consideration to find a decision. And that's why he believes that the hard cases are a good example to show that the prohibition of the denial of justice is one of the main motives of the centrality of the courts. But what is the? It's good to take the quotation 4 and to see what Luhmann is saying about the hard cases. Hard cases are cases in which the existing doubtlessly valid legal norms applied with logically correct deductive method do not lead to unequivocal decision. These are cases in which the knowledge of uncontested and valid law is not enough to state the fact of who is in a legal position and who is an illegal position. Nevertheless, courts have to decide these cases as well. This means courts have to develop rules of decision-making for their decision and for its justification, which may be contested and may remain contested. So, in hard cases, the courts refers to some moral law or some consideration, because they are obliged to find a decision, to come to a decision. So this discrepancy between compulsory decision-making and the possibility of arriving at compelling decision find its expression in the legal institution of legal force, which prohibits appeals against decisions which can be even contestable, says Luhmann. The question he asks is, what is about the prohibition of the denial of justice, which sets so much emotion? The answer is that this prohibition is an ontological rule, which includes itself and its application. As a statement of ontological rule, ontological rules apply themselves, they don't have any justification. If a compulsory decision is ontological, non-decisions are excluded because they violate the rule. But why? By whom this rule should be enforced? By the courts themselves. So the courts themselves have rules they apply, and this rule has no justification other than the justification given by the courts themselves. And for Luhmann, this ontological property refers to a deeply situated paradox. Courts have to decide even if they cannot decide, or at least not within reasonable standard of rationality. And if they cannot decide, they must force themselves to decide. If the law cannot be found, it must simply be invented. And this, for Luhmann, is a paradox, the paradox of what he calls undecidable decision-making. But this undecidable decision has to be taken. So there is an obligation to decide even when they are not able to decide rationally. And this is the quotation 5. Luhmann says, the paradox of the undecidable decision has to be unfolded in one way or the other. And that means the decision must be translated into distinction which can be managed. For example, the distinction between decision and the consequences, or between legal principles and its application. And this has consequences for our conception of legal justice, and raises the question why we come to accept the verdict of tribunals, of courts. It has consequences for our trust in courts. Luhmann sees the process. Luhmann sees in this process the impossibility of a logical foundation of law, a non-rational foundation, and at this level, these conclusions are not different of the conclusion of Derrida, for instance, who says that law is arbitrary. The foundation of law is arbitrary. And Luhmann quoted even Derrida to say that Derrida is right, because if courts are obliged to decide, even when they cannot decide, the decisions cannot be logically acceptable or normatively acceptable. And this, he says, undermines citizen confidence in the legal system, for the reason sociologists can explain more than Luhmann does not explain it, but in fact what is important for him is this loss of confidence in the legal system. That this denial of justice cannot be explained by the legal system itself must be clear. It cannot be proved that there is no alternative, says Luhmann. But sociologically, it is the result of the awareness of the complexity of the world which led people to give, which led the court to give up, the system to give up the pretension that problems in the world can be treated logically or only theoretically. Human condition demands reduction of complexity. The endless interpretation of the word or text must be interrupted. One has to act, says Luhmann. One has to make decision quickly and not look for the best decision which perhaps cannot be found, since we don't know the consequences. But since judicial reason cannot be found, since we don't know the consequences, so since judicial reason demands a decision, decision must be taken. The legal institution provides institutional means for that. And this is the way Luhmann described this institutional means. He says, quotation 5, the prohibition of the denial of justice does not follow either from the fact that the binding force of statutes does not leave any other choice. For as soon as there are problems of interpretation and application of statutes, a judge will be free to find a gap in the law and reject to make decision. Hence, there must be institutional provision if the legal system is to be arranged as universally competent and at the same time capable for decision making is expressed in the proposition of the denial of justice appropriately for the legal system in the form of norm. This, however, means also that the claim to validity may, if necessary, be maintained contrafactually. So, validity can be maintained even if there is an evidence that it is not be defended. This decision cannot be justified. For this reason, Luhmann restated the well-known argument that law presents itself as closed, autological, and autoreferential universe, which makes decisions according to its own rules and criteria of rightness. In the whole legal system, no organ is obliged to take decision. Courts, however, have to decide each case that is submitted to them for legal reason. Only courts are in charge of managing the paradox of the system. However, one may define it. Only courts have to transform indeterminacy into determinacy where necessary. Only courts have to construct fictitiously the availability of principle where necessary. Only courts are forced to decide, and consequently to enjoy the privilege of being able to transform compulsion into freedom. No other legal institution commands a position, and it is true that courts unfold the paradoxes of the legal system according to the prohibition of the denial of justice. Then one has to abandon the model, the old hierarchical model, and replace it by the central and peripheral model. The center will be the courts, which are obliged to decide, and so, by so doing, unfold the paradox of the whole legal system. The other parts constitute the periphery, which has no obligation to decide, or even if a decision is impossible. Because of their central position in the system, courts work in condition of cognitive isolation. For Luhmann, this decision-making is guaranteed by the fact that the judge is not responsible for the consequences of his decision. All the parts of the system belong to the periphery because the judge can take the whole load of the legal system. So Luhmann seems to say that because there are alternatives are possible in the legal system, why choosing to put more emphasis on the idea that the courts are only there to decide decisions which are impossible to decide? Why is Luhmann trying to deconstruct the function or the role of courts here, instead of saying that we can just see things otherwise, since there are possibility to expect from courts to find other way to decide and not be obliged to decide when they cannot decide? Why is Luhmann not making proposal for a change or a critique which could be constructive of the or which can correct or lead to reforms of the legal system? So this is the question with which I want to finish this presentation. But the main idea here is that there's no justification of what courts are doing, because the central position allows them to decide even if cannot give reasons for their decisions. So this is, if we take it seriously, a very strong analysis, very strong thesis on the function of the courts in the legal system. Thank you very much.
I think we have some time to open for 2 or 3 questions. Anyone? Marco, please come here to...
No, I don't know.
Não,
Which one? This one? We can. This one?
Ah, esse daqui é igual de igreja.
Evangélico.
My question is directly to Professor Chris Thornhill, but you can answer if you prefer, and if you so my question is simple. Your argumentation is about the relationship between military and legal and the political system. So my question is, what happened for you after 1945 in order to restabilize or rearrange the problem or the lack of stability in the relation or in the outcome of the relation between legal and military system, or okay?
Could I take the mic? Is that...
Yes.
Thank you very much indeed for the question. I was trying to present the first half of a paper. Obviously, Carina's paper and my paper, they speak to each other very closely, but they're not yet fully amalgamated as in happy union. It's the key question in the whole debate, and the argument that I want to set out is tentative and historically nuanced. In that I don't wish to say that this happened immediately. I think it's a process which took place in a staggered sequence in different ways in different parts of the globe. We did from 1945 onwards see the emergence of democracy very slowly and gradually as an institutionally stabilised form, which it simply wasn't before 1945. With a couple of exceptions, there weren't really any national democracies. Some got close, but there were only 3, 4, 5 possible national democracies. And the reason for this, in every case, is that national citizenship is connected, because of its original connection with military mobilisation. National citizenship becomes very closely linked to international conflict. And different social groups within national societies internalise a relation to global conflicts within their own practices. So that national democracy is almost invariably becomes patterned on civil war, closely linked to global conflict. And so the construction of law became greater. And the extent to which the military system was able, or determined the construction of law, was reduced. It didn't disappear. And this took place in different ways in different societies. But I think, like Carina, linked this very clearly to the emergence of a system of global norms after 1945, particularly to the emergence of a system of global human rights law, so that for the first time the international domain became populated with normative points of reference which were not about global conflict. So it became possible for interactions within domestic societies to refer to legal constructions or normative constructions outside national society, which did not intensify conflicts within national society. In fact, they tended to soften them, because the penetration of international human rights law promoted processes of constitutional stabilisation, above all processes of individualisation, which tended to reduce the volatility in the interaction between social groups and social organisations within national societies. So it's the emergence, what I call a hyper-differentiation of a global legal system, which is very strongly attached to the rise of international human rights law, which then penetrated back into national societies to underpin national legal systems. Above all, national legal systems were able to legitimise the production of law on principles or on premises that were actually abstracted against factual conflicts between citizens, because after 1945, in every democracy, the final residue of legitimacy is human rights. It's not conflicts between social groups. So this leads to a kind of depoliticisation or demilitarisation of citizenship, so that democracy actually eventually developed not around citizenship. Whereas in classical democratic theory or classical constitutional theory, the citizen is the irreducible source of legitimacy, thereby, through this, connecting the legal system to the military system. But after 1945, the citizen actually became a secondary force, in that it's perfectly possible in most democracies to create legitimate law without citizens. by referring, I mean, it happens all the time. Carina's just given a load of examples of this. It happens all the time. It's perfectly possible to legitimate law simply by referring to an international treaty or an international human rights law. So the citizen moves to a secondary position. So you actually see a weakening of democracy in the classical sense of the word as a precondition of democracy as a stable form. But this is what I would identify, whilst at the same time accepting Carina's argument without any shadow of doubt that the hyper-differentiation of the legal system is itself a dangerous process. And it can corrupt democracy. So it's, I accept this categorically, and this is Carina's insight, not my own. In that I think that one can present this process as too smooth and too easy and too linear. But I do think that at the level of historical sociology, we can arrive at two conclusions. One is that national societies based on national citizenship did not create democracy. Hardly existed. Secondly, that the precondition for democracy as a constitutional form is that citizenship became demilitarized, so that the actual concrete conflicts between citizens lost their status as the primary source of law. And because of this, I think this is very important. The tendency for global conflicts to simply reproduce themselves in conflicts between domestic citizenship groups was weakened. Whereas, and it's this fact in particular, the intense and intimate correlation between intergroup conflicts in national societies and conflicts at the global level, which destroyed all democracies in the interwar period. Because every social group within domestic societies had to position itself in relation to Moscow, to the Bolshevik Revolution. And this meant that every interaction between political organisations within domestic societies was based on a zero-sum calculation, because there couldn't be any collaboration between social organisations that were close to Moscow and social organisations that were anti-Bolshevik. After 1945, it's a paradox, because global conflict became in some ways more dominant through the Cold War, and this was reflected in Latin America, of course, immediately. But over a longer period of time, the tendency for global conflict simply to create binary oppositions within domestic societies was weakened. Ultimately in Latin America also, in that the democratic transitions in the 1980s were based specifically on an attempt to split domestic conflicts from global conflicts, and human rights law was used as a means to do this. I think we see this most paradigmatically in Argentina, but in Brazil to a lesser degree. Now, I would say tentatively that at the moment we're witnessing a period of retrogression, very clearly, and some of the things that Carina describes are pathological expressions of this retrogression, I think, where the human rights law is becoming weaker, the articulation between domestic political systems and the global normative system is also becoming weaker, and very clearly, I hate to say, but Brazil is a case in point. There's actually an inflationary attachment of domestic political conflicts to global conflicts. So I think there is empirical research to be done not only on this historical process, but on the legacies of this historical process at the moment. And I think Carina kind of does this, whether intentionally or not. But this is implicit in some of the things that you said. But thank you very much for the question. I hope that's a satisfactory answer. Yeah.
Questions?
I have a question.
I have a question for you. Yes. What do you say that there's that the legal system does not have any idea of inclusion? You say it many times. I don't.
It's not that it doesn't have an idea, but it's not sufficient to promote inclusion. Because, comprehensive. Because I think we deposit too much faith in the legal system, but we have to see better the limits of the legal system, at least the legal system as proposed by Luhmann. Because that's the question, the code of the legal system is not inclusion, not inclusion. Maybe if you think about human rights, the human rights are driven by a logic of inclusion, not inclusion through rights.
Equality as one of the major concepts of legal systems.
What Luhmann says is that you have a code, legal, non-legal, and then you have the reference of justice. And then by justice it says equal treatment. But equal treatment for the ones that are already included in the legal system. Because then that's my question. If you have a legal system, for example, that declares the amnesty is illegal, victims of violence of human rights, they are not included in the legal system. If you have a legal system that accepts slavery, then slaves are not included in the legal system. So there we need something else. If you really want, if the final goal is to promote inclusion and inclusion through rights, we cannot only depend on the legal system. We need this, I don't know, maybe human rights, maybe like a meta norm that is going to cut across, and not only the legal system, because we need the other systems as well. We need to think about inclusion not in terms of the legal system, but in the political system, education system, and the religion system.
Luhmann does it. I'm sorry. No, I'm so sorry.
No, you say Luhmann.
Please, I didn't want to interrupt.
I just want, if you should take, since we are talking about empirical research, if you take the example of many constitutions and democracies, I mean the movement of inclusion exists in terms of fundamental rights, but they belongs also to this movement belongs also to the legal system of democracies. So how far can you generalize your argument?
It's perfectly possible to have a legal system without human rights. No, Carina, it's your question.
You respond and then I respond. You have things to say. Let's share.
It's a very interesting question. I mean,
Thank you.
I think Carina's point, if I understand it correctly, is that the construction of the opposition between lawful and not lawful is always entirely positivistic. So it doesn't. It only promotes a construction of. I think you're using a different understanding of inclusion from the understanding of inclusion that Luhmann would use. It's nothing that you say is wrong for that reason, but inclusion is simply legal inclusion. It's simply inclusion under the code, lawful, not lawful. Yet, this is obviously a very thin form of inclusion. But I think there is a different dimension to what I'm saying. I'm not really wishing to put words into your mouth, but just more by extension or by implication. There's a suggestion that the rights, not rights, or access to rights, no access to rights, or relevant for rights, not relevant for rights, is a metacode for law and politics together. It functions as a metacode. If you conceive of law and politics, I mean, in Luhmannian terms, this would be anathema or heresy. But as I implied before, I don't think that Luhmann really does distinguish between law and politics. But if we begin to reconstruct law and politics together as a system, then the code would probably be rights, not rights. And this would drive a deeper process of inclusion than the process of inclusion that you found in law. I agree with you. Using your construction of inclusion, of course, the Luhmann's construction of the legal system will not drive a powerful process of inclusion.
So thank you for the comments and thank you for the very good questions. It's makes me reflect. When I think about inclusion, I think about full inclusion, and by that I imagine like inclusion in what I say essential partial systems. And essential because they are related to fundamental rights and human rights. Of course, you can be included in the system of law and not be included in the system of education or not be included in the system of politics. And there is one of my colleagues is going to present here in a few weeks, and his name is Edivaldo Moita. He's doing his research at the University of Bielefeld. And his work is very interesting, and it's based on empirical research. And he's talking, and I think this describes well my argument. what he says is that sometimes when you're included in the legal system, this can be exclusionary. So his research is based on Fortaleza and then on legal works, on informal forms of work in Brazil. And what he says is that when these individuals, they are practicing informal forms of work, they are more included when they are forced to be included formally in the legal system. So what he says is they starting to have, they have to pay taxes, they cannot organize their business in the same way, so by being included in the system of law, they have some rights excluded. So when I think about full inclusion here, I think something that sometimes goes beyond the idea of legal and non-legal. And I think about that as well when you think, for example, in the prison system. So some individuals who go to the prison system in Brazil, they are included in the system of law because they commit a crime and now they are in prison. But by being part, by by addressing this idea of legal, non-legal, they are being completely destituted of fundamental rights. So you're thinking there about legal, non-legal, but you're not thinking about full inclusion of these individuals.
Yeah, thank you.
And now we will have only more 2 questions by Professor Guilherme Azevedo and Professor Álvaro, please.
Thank you. My question actually is always this commentary. I think the main issue here is that integration and inclusion is not the same thing in Luhmann. So I think there is a mistake here. When you talk about inclusion, is not the same thing that integration, and exclusion is not the same thing that disintegration in Luhmann. So slavery could, I think if you can say that slavery in legal system could be an inclusion in law. Of course, yeah. So there is some points that use inclusion as an integration question and exclusion as a disintegration question. I think there's not the same thing, Luhmann. It's complicated to use as a synonym, and it's not the same thing.
You have one more.
Carina, thank you for your presentation. I found it very interesting because I'm working on other side, and Guilherme, I think you also introduced the problem that is about this double sense between integration and inclusion, but I liked a lot the idea of full inclusion, because in the matter that I'm working, that is a criminal law, we can see that the Constitution, European Constitution, in Article 2, auto-design death penalty. Sentences in Brazil are a problem of inclusion in the system, but exclusion of the full inclusion, as Carina is talking about. So I think when you are connecting inclusion, exclusion with women's rights, there is something more like a simple movement. And we need to know if the distinction, integration and inclusion will help us or not in terms of the content. So the direction that Carina takes, it's interesting, at least for the problem that I'm dealing, because I'm dealing on the other part of the problem. She's working on the first phase is, for example, for the victims, etc., etc. The other is the way you will do justice after that, because otherwise you will undoing after. For inclusion, you are putting people to death or to prison for life, still in Canada. So I think that here is material for reflection for us, because if you are concerning also with the construction of a better system inside of law, we need to go and to think in the distinctions that we are putting together to see if it's to avoid to continue a paradoxical situation in what we are doing bad to do good inside the system.
I'd like to make a comment. Thank you, Guilherme. I do think that we have to, give a better look about the concepts in Luhmann of inclusion and integration. They are not the same thing. But I guess what I'm proposing here is a different concept, because what I actually see is that sometimes we have inclusion in the system, but we have exclusion of rights. And then what I'm thinking is, where are these rights located? Because they are not only located in the legal system. Sometimes they do not exist in the legal system as we understand. Sometimes they are in other systems. Given the due credit, I started to think about full inclusion through Chris, because we are having all these conversations about democracy and how democracy is an illusion. What we think about democracy as like England have democracy, other states having democracy, is not real democracy, because you just have inclusion of part of the society. And then when you think about full inclusion, it's all parts of the society. But then I'm going one step ahead, and I'm thinking about full inclusion, not only under the limits of the state, of democracy as something connected to the legal state, but full democracy in the inclusion of a global system of rights. And then when you think about this global system of rights, you have to see victims of human rights, you have to see individuals, and maybe now we have been irritated to think also beyond individuals, to think about animals, to think about the environment, to think about the Amazon, not only connected to individuals, but to think about rights that are not only limited to the state. And I think that when you have a situation like you have right now in Brazil, you can see that the code of what's legal and illegal, and to be included in the legal system, has been turning the protection of rights weakened. And we have to try to look about the defense of these rights and about the inclusion of a series of individuals elsewhere. Not only in this idea of inclusion only based on systems, but elsewhere. Not thinking only systems, but thinking about rights. Maybe think about this global system of rights. I really don't know exactly how to locate this in Luhmann's theory. In terms of
You go. I don't know exactly.
I mean, I think your argument's completely plausible. Just because I'm just paralleling what I said about politics with what you say about law, and the assumption I'm not really a Luhmannian, but there are some. I don't wish to be puristic about this in any case, in systems theoretical terms, but the concept of the political system in Luhmann presupposes inclusion. It presupposes inclusion at two levels. It presupposes inclusion in that everyone is subject to power, or all social exchanges, all social communications are subject to power or not subject to power. So the political system is necessarily inclusive, but then that raises a question of what and it's inclusive in some notionally equal fashion for all people that are subject to these exchanges. So that raises a question as a corollary, which is what equal inclusion actually looks like. And equal inclusion as a minimum would involve the exercise of the free and equal exercise of citizenship rights by all people. So that would be inclusion. So there's an impulse towards full inclusion built into any political system, and in a way Carina is quite right, I think, in that it's perfectly possible to construct the legal system even in Luhmannian terms by saying it contains an impulse towards inclusion, and at a purely positive level that simply means that everybody is subject to legal decisions made within the courts in equal fashion, so that they're binding equally for all people. That would imply inclusion at this very crude level. But how can that actually be the case? How can that actually be the case if it doesn't entail an implication of full inclusion in Carina's sense of the word? How can that be inclusion? It's like reading the implications of Luhmann's theory of inclusion against its express or intended implications. As soon as we begin to try to imagine what inclusion in that sense means, then it begins to mean something very similar. I mean, we're not writing the same article in this sense, but it begins to mean something very similar to what Carina said. And in both instances, whether we look at the political or the legal system, what determines inclusion is rights. This is why I always come back to this point, that there's a meta-coding for politics and law together, which is rights, not rights. Now, rights in the political system, in the first instance, would entail the exercise of electoral rights. But rights in the legal system may include very different rights. It may include procedural rights, or be particularly focused on procedural rights as means of inclusion. But the equal exercise and the equal enjoyment of procedural rights in order, as a foundation of legal inclusion really begins very soon to look like something very similar to what Carina's describing. I'm not meaning to take your argument for you, but is this continuous with your other thinking? Thank you.
I think it complements, goes in the same direction. And then I think it's important to think about rights and also about law subjectivity. What are the subjects that are entitled to these rights? Because then again you're thinking about inclusion. So some 100 years ago you would not have slaves, and then now in some parts you do not have indigenous people, and then you already have a discussion about animals, and then I bring again here environment. You think about rights, but also the ones who are entitled to these rights. And that sometimes this is out of our imagination, it's out of the reach of our imagination, because it's not in the legal system, but then how to bring it, for example, environment to the Brazilian legal system. Nowadays, you have economic pressures, then you have economic pressures, they are included in the economic system and in the political system, but by the legal system it's not defended.
This is right.
Yeah. So, I'd like to thank you all, Professor Lukas Sosoe, Carina, Professor Thornhill, and the professors that presented the lectures at other days, Professor Guilherme Azevedo, José Roberto Xavier, Professor Álvaro Pires, and to thank my colleagues, Marco Barros, Gabriel Fonseca, and in first place, the one who made all this idea possible, that is Professor Celso Campilongo. And I would like to invite everyone to our seminars in September 18th, that will be about technology, about regulation, and then with Professor Bora about legal sociology and social legal research. So, see you in September.